There is a case that has put abortion laws and women's rights in India back into limelight. It is about a 27-year-old married woman wanting to terminate her 26-week pregnancy. Here is a summary of the case so far. The petitioner had sought legal recourse because she had missed the permissible window of medical termination. She had told the court that her contraceptive method of lactational amenorrhea, since she was breastfeeding her second child, failed. This resulted in a pregnancy which she discovered much too late. The bench of Justice Hima Kohli and Justice B.V. Nagaratna in its October 9th ruling allowed her to terminate this pregnancy. In the order, a report from an AIIMS medical board states that on October 26th, the petitioner was 25 weeks and 5 days pregnant. The permissible cutoff allowed by the Medical Termination Pregnancy Amendment Act of 2021 is 24 weeks. However, Chief Justice of India D.Y. Chandrachud stayed the abortion. Why? Because one member of the medical board had written to Assistant Solicitor General Aishwarya Bhati saying that it was a viable pregnancy. Thus, to terminate the pregnancy, the fetal heartbeat must be stopped. The matter was again heard on October 11th by the same bench, which resulted in a split decision. Justice Kohli had changed her mind about permitting the abortion, while Justice Nagaratna ruled in favor of the petitioner. On October 12th, the matter was heard by three-judge bench, presided by Chief Justice Chandrachud. The bench expressed its concerns about allowing the abortion, saying that terminating this pregnancy at this point, after a medical report indicated that the fetus has a good chance of surviving, could be considered foeticide. The bench also suggested that the counsels might talk to the woman about continuing the pregnancy. On October 13th, the bench was told the woman was unwilling to continue the pregnancy because she was undergoing treatment for postpartum psychosis. The bench, however, doubted the authenticity of the prescription that she had provided to the court about the medications that she was having and ordered the AIIMS medical board to assess the petitioner's mental and physical condition. The board has also been tasked with suggesting alternate medicines if the petitioner had postpartum psychosis. While this has triggered intense discussions about women's rights, intersection of pro-choice legislation and protection of fetal life, rights of an unborn, and how abortion is defined in India legally and medically, let's go deep diving.
A viable pregnancy is one where, if by a process of either natural premature labor is born by assisted ventilation, the baby can be resuscitated and may be allowed to survive and grow into a normal individual, then that baby is, possibly can survive and become a normal individual.
The legal system, as I said, mentions this trimester test. So whether it is the older act or the newer act, it's not so much a question of a viable pregnancy, because medical science can keep, going ahead and, creating more and more viable pregnancies. But the question is of a woman's right. And what happens if you deny her the right? As they say, my body, my right. That's a term we use in so many things, whether it is sexual harassment or marital rape or anything else. But that's also true here. My body, my right. So I should have the right to decide whether I want to carry out that pregnancy or not. I can't decide whether to have a female or a male child, but I can decide not to have this child. So I think that is what we really need to focus on, and not the viability. So law just looks at it in terms of these trimesters. It does not really look at fetal viability as, being the test.
See, lactational amenorrhea basically means that when a woman is breastfeeding her child, there is a hormone called prolactin. Now, prolactin, when it rises in pregnancy, it is very episodic, and that is how there is a milk letdown. And when there is a milk letdown, this prolactin tends to inhibit ovulation. As a result of not having ovulation for long periods of time, there is no periods. As one would understand that since the ovulation is very erratic, one understands that if there's no periods, there is no pregnancy. So lactational amenorrhea is a time when there is a very low chance for pregnancy, but it is not no chance for pregnancy. See, medically induced pregnancy termination would be that a woman who wants to terminate her pregnancy for whatever may be the reason, where she doesn't want the pregnancy, and you need to give tablets, or you need to give whatever it takes to get the pregnancy out of the uterus. And this can be done within the first trimester of pregnancy, that is, within the 8 weeks of pregnancy. That is medically terminated pregnancy, that is, using medications, oral medications, to terminate the pregnancy. The second one is medically induced, would be there must be a problem in the pregnancy. For example, there must have been an abnormality, or there could have been a blighted ovum, or there could have been an absent heartbeat, and therefore there was no use of continuing the pregnancy. Therefore, there is a medically induced termination of pregnancy. The third one, as I had already told you earlier, is that a woman wants that pregnancy to be terminated because it was an unwanted pregnancy. So this is the three ways of defining those terms. It's a question of English, and it's a question of understanding it. Medically advised could be due to some medical problems or comorbidities that would have been told to the patient, A, because the pregnancy is not continuing, or the pregnancy is abnormal, and therefore it would be advised. But medical termination of pregnancy, that is the MTP Act, would be that under certain conditions, the termination of pregnancy can be effected. The medical termination of pregnancy is a right that women can exercise under certain guidelines. From an embryo to a fetus, it is at 8 weeks, because when the placenta takes over from the corpus luteum, that is the 8th week placental shift. So it becomes from an embryo to a fetus. That's the time you'll be able to see it on the scan as well. And you need to help them out. If you talk from embryology perspective, it will be around the 17th day post-fertilization. If you talk from ultrasound, it will be the 5th week transvaginal scanning, or it will be about 6th to 7th week on an abdominal scan. Well, a fetus at 8th week, it would be easy to sort of abort, only because it doesn't have that much of, bone thickness, etc., and it would come out very easily. But when you look at 20 weeks, the fetus has all the organs formed, the size is much bigger, and you may not be able to take just these tablets and get them to abort, but you will have to have a mini labor to get the fetus aborted. It's like a mini labor, like a premature labor. At 20 weeks, you may not get, the baby may be about 500 grams or half a kg. So you will be able to get the baby out, but the lungs are not mature enough to be able to survive outside. But when you look at 24 weeks, these babies are viable. So if they've been monitored well, they can be anywhere between 800 to 1 kilo. And the lung maturity, to the extent that the bronchioles, that is the terminal part of the lung air exchange, and the alveoli are just forming. So when you say 24 weeks, there are chances that these babies, when they are aborted, can also be alive. And it becomes very difficult to say that, no, this baby has to die. So we can't play God. Therefore, we need to say that we have to put a cutoff. If a baby can be independently existing without the mother's umbilical cord, then we have no right to terminate that fetus. Organogenesis, as in development of heart, development of liver, development of gut, development of brain, development of all the sense organs. So if you're looking at lungs, or you're looking at the esophagus, the windpipe, so basically thyroid. So these are the organs, or the development of the anus, or you're looking at any of the development of the basic essential organs, all happen within the first 12 weeks. Basically, 6 to 7 weeks is what we are expecting for the internal organs. So external genitalia will develop between the 7th to 8th week. So whatever actually happens has to happen during that time. So that's a very crucial period. There is no single person other than God who can tell you that drugs will not affect the pregnancy. Okay, point one. Secondly, there is no drug or not drug company or pharmaceutical agency who will boldly write on their product that this is safe in pregnancy. You must understand that there is no way ethically to do trials on pregnant women to see whether it will harm or not. Well, I said no. In the first trimester, when the organs are being formed, that is the time which is very sensitive to any kind of drugs, chemicals, compounds, or whatever you say. Thereafter, it is only a growth. So the growth can get affected either in the form of nutrition being deficient, or the delivery being malfunctional, or the amount of fluid around the baby so that the baby cannot move adequately. So therefore, there could be movement restrictions, so the body doesn't grow. Or if the nutritional deficiency is there, the baby's growth is restricted. So you may see growth restrictions and all occurring, and abnormalities in terms of organogenesis would all be in the first trimester. The rest of it is more on a functional component rather than on anatomical component.
No, there are no fetal rights as such, because as I said, unless a fetus is born alive as a child, and then you have to take care of that child, and as long as the fetus is in vitro, in the womb, it has really no rights whatsoever. And in fact, the only law that really governs it is the criminal law, which says that if you have an abortion which does not fall within this parameters of the act, etc., then it would be a crime. It would still be causing miscarriage, So the entire legal system, we are trying to move from that criminal angle to looking at it from a women's rights angle, but nowhere are there fetal rights as such, because rights are only there in human beings, and a human being has to be born alive to be a human being. I said a fetus is not a citizen. A child that is born is a citizen. So you become a citizen by birth, or of course if you acquire citizenship, but definitely by birth. So a fetus does not have any rights in that sense, because it is not a human being yet. The rights of a fetus in law are only if the fetus is born alive. But we have what we call rights of unborn. Unborn are those who will be born as children. Succession rights, for instance, if there's a posthumous birth, that the father has died and the child is born, the child can still claim the father's right because the child was in the womb and was born alive. But if the child is in the womb and the mother has a natural abortion or miscarries, then there is no question of the child getting any rights. So fetal rights are something that, the legal system does not really recognize at all, under any circumstances. If you look at it from a constitutional perspective, then, the only citizen in this whole thing is the woman.
Correct.
A fetus is a fetus. A fetus is not a child. It only becomes a child when it is born alive. So until that time, there is really no no real legal personality as such to the fetus. So it really cannot be divisive in that sense, because you're talking about constitutional rights of a person who is there, that is the woman who chooses to have or chooses to terminate her pregnancy or not. As I said, the 1971 Act was a shift. It was mainly an exception to the criminal liability. So until then, it was a criminal liability if you had an abortion, and it allowed for it legalized abortions by what are called registered medical practitioners. One of the main features is that the gestational limits were increased in the Amendment Act. Some things, there were no changes. Like until 12 weeks, generally in pregnancies, they follow what is called the trimester test. So, in the first 12 weeks, the first trimester, so to speak, under both the laws, both the old act and the new act, you could have, an abortion with the advice of one doctor from 12 to 20 weeks, the 1971 law said advice of 2 doctors, but the 2021 law said advice of 1 doctor. From 20 to 24 weeks, the older law allowed an abortion only to save the life of a pregnant woman, but the later law allowed this to happen even in case of other kinds of conditions as well. So it's basically made abortions easier. But what is important to keep in mind is that it's still very much medicalized. That it depends on what the doctors say or the medical boards say. Under the 2021 Act, and that is what the present case is also about, if you read one decision to the other, is after 24 weeks, under the 71 Act, it was allowed only to save the life of a pregnant woman. But in the case of the 2021 Act, it is approval of the medical board, etc. So this, though in some cases the number of doctors needed have been reduced, which makes sense because women in many places don't even have access to these doctors. But still, the approval of a medical board is needed beyond 24 weeks. But if we look at the second opinion, it's not the medical board's opinion in that sense, but what the medical board had asked for, had said was, it wasn't even the medical board that had said, it was that one doctor. If you look at her opinion, I think that's really important in trying to understand why the court said the way it wanted to. Because it says, for instance, that as a baby is currently viable. So it's not saying fetus now, it's saying baby. The words used are very different. As the baby is currently viable, and this is available if you look at the Supreme Court thing, it will show signs of life and have strong possibility of survival. We will need a directive from the Supreme Court on whether a foeticide, that is stopping the fetal heart, can be done before termination. We perform this procedure for a fetus which has abnormal development, but generally not done in a normal fetus. Then it says if a foeticide is not performed, it is not a termination, but a preterm delivery, where the baby born will be provided treatment and care. Okay, a baby born who is preterm and a term and also such low birth weight will have a long stay in the ICU, etc., etc. It says. So, and then it also gives adoption as an option. Now, this doesn't come from the board. At least the way it is quoted in the court. It says addressed by one of the members of the board, which is one professor. So I'm not really sure how, what the legality of that is, because otherwise it says medical board. And if you look at the words of it, it's really, it is problematic in many ways, but it's very different from what the earlier board opinion was, which is very, do you recommend, do you not recommend? So after reading this, I think we see that there is a divergence of opinion. So if you look at the words of the medical board in the October 9th decision, and you look at the words that this one doctor has said later, it is very, very different. This is the one it says.
Oh, okay. Yeah, Parna Sharma.
This application is on a subsequent email addressed by one of the members of the board, and that says this. This is the 11th October decision, okay? So it says, as a baby is currently viable, if you see para 1. So it seems it's the doctors asking the court the question, should we do a foeticide, which is what it's talking about, or should we do a preterm delivery by whatever, induced labor? And then, how do we go about it? And then it also conveniently throws in things that if it is to go for adoption, number 3, which is, so it's really like overstretching and saying things. And obviously then this affected what the court said.
While abortion in India is still criminalized, exceptions to that have been defined by the MTP Act. The July 22 Supreme Court ruling recognized the rights of unmarried women. What this case would define or redefine remains to be seen. The case will be revisited Monday, October 16th, 2023. I am Prija Arvind, and thank you for watching India Today SoSouth.